Didn't hear us talking about having to read all that stuff Sunday.
I heard you.
Okay. Well,
Sorry about that.
It's 9 o'clock. Mills County Commissioners Court is called to order. If you would stand for the pledge and a prayer. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Dear Heavenly Father, be with us this day as we do the business of Mills County. Guide us and direct us in all our actions. Please, dear Lord, bless this land with some rain that we mostly really dire need. Yeah, dear Heavenly Father, thank you for everything that you have bestowed on us. In Jesus' name we pray. Amen.
Amen. Well, present in the courtroom, we have myself as county judge, Commissioner Wright, Commissioner Gearing, Commissioner Hall, and Commissioner Williams. So we have the full court and thus a legal quorum. We also have County Attorney Gerald Hale and County Clerk Sonia Scott. We have in the audience Dale Parton. We have present via Zoom Treasurer Trina Busby, and at the Mills County Law Enforcement Center, Tina Allensworth. And it looks like the Goldthwait Eagle is on with their a bag over the camera. So let's get started. We've got a large and interesting agenda today. The first item on the agenda, did we have anyone sign up to speak, Ms. Scott?
Yes, sir.
Okay. We have the minutes of Mills County Commissioners Court of October 26th. Any questions or discussion or correction on the minutes?
On our agenda, we need to correct it too on our agenda.
Okay.
Instead of Tuesday, November the 9th, we need to go Monday, November the 9th up to the top.
Yeah.
The very top. Yeah. That's the only thing I say in minutes. I've seen nothing in the minutes.
So I notice we have on the agenda the minutes of 26 and 29. What we have for approval here is the minutes of 26.
The election kind of got in the way of the minutes of the 29th. They're typed up, but I need to get them a little more pretty before we send them out.
Understand.
I make a motion that we approve the minutes of October the 26th, 2020.
I'll second.
We have a motion and a second. Any further discussion? All in favor say aye. Aye. Minutes are approved. Audience with individuals, we have no one has signed up to speak. We have the monthly consent agenda. Ms. Busby, I had a question on the, and we may have fouled this up in assembly. The agenda says monthly county treasurer's report. What I have is the quarterly report. Or should we have a monthly? Or does anybody else have a monthly in their package?
I get my monthly on an email.
Okay.
I'll receive
You
it.
should have a monthly. I gave her a monthly one for everybody.
Okay. What would, Commissioner Wright, did you say you had a monthly report?
Yes, on email. They send it. She sends it out.
Okay.
I get it on my computer's house.
Yeah.
No, that's the budget analysis usage report, which is
Yes.
different than the monthly report.
Oh, okay.
The monthly report is just 2 pages. You should have 2 pages. The top line says on this, the 9th day of November, 2020.
No.
Do y'all not have that?
Yep. No. Do you have it, Commissioner? Okay.
It's in my package.
It's, okay.
Mike's handing it to you. Ed,
Good.
Yeah, that's the quarterly report, I believe. Yeah. No, you're right. It is.
No, this is the
It's the monthly. I
That's monthly.
misread it.
Yeah, it's
Okay, that's my error. We have the monthly report showing receipts of 323,000, disbursements of 553,000, rounded. And the second page, the fund balances and liabilities. Just to quickly run through what else we got. We got the accounts payable report over the weekend via email, about 13 pages. Anybody have any questions or go ahead?
Precinct 3, page 5, that Sandbell welding, and so it's the tractor on the shredder. That should be under the
Road and bridge.
road and bridge, not under your.
Okay, we'll change that.
There's also, there's another one on there for what, 185 or something for the rings? That's further down.
Right.
It went under road and bridge, did it not?
Yeah, I'm saying this one needs to move down to that one.
What's the charge it needs to move?
So it needs to go, it's $75, it's,
Sound bell.
Sound bell welding.
I might just point out on the Goldthwaite Eagle expenses, the 4 notices relating to the wind farms have been billed out to the applicants for reimbursement. So we'll
I
be,
know, I saw that, that was a lot of money for all those notices.
Yeah.
Have you ever done anything over there?
so anyway, we're paying it, but we have the bill out, and if all this has to be paid before our hearing on the 22nd on the abatement. Any other comments on the accounts payable? Okay, then we have the monthly collection report from the Appraisal District showing 91.7, effectively 92% collected. Of last year's taxes. We are just now coming into the current year, and they haven't they probably have started paying. The problem remains the Encore Sherry Land. That's the whole difference. In last year, there is the first court hearing on that appeal. Let's see, I've got the date. It's November 24th. And after that, I'll have an update for the court on what happens. That's not a trial. That's just a motion with, best I can read it, the attorneys for the Appraisal District have filed citing their case law and asking for dismissal. So we'll see. Next item on the agenda, the county extension agent report. Let's see, about 160 miles of travel. And coming up in this month, district livestock meeting in San Angelo and a number of ranch tours and new landowner events. The Sheriff's Department report, 264 calls, about 20% of them are EMS related. 10 arrests by our Sheriff's Department, new jail bookings, which reflect DPS arrests, game warden arrests, and other counties of 21, and jail housing of $4,700, and 100% of that is San Saba. The JPs report is the next one back. It's a lot of numbers, but the way I look at it, line 2, new cases filed, you can see 75 non-parking cases plus 4 penal code cases and 14 other cases. And then down on line, let's see, 10 cases disposed. So we had 75 filed, 43 disposed, just staying in the first column. You can read across other columns. The second page is civil cases, civil activities. See 1 case filed. That's primarily things like small claims and eviction. Next page is juvenile, and it's blank. And the last page is the financial page down at the, you can see magistrations up at the top, and then down at the bottom, fees collected of $12,784, of which the county receives $72.40, the balance going from the state. The county judges collections are the next one back. Interesting, very small rental fee from the senior center, although 16 days of senior center use. That was primarily the election. 5 septic permits issued and $1,150 of septic fee income. Now, round numbers, about half of that ultimately goes out to our septic inspector. We do not have didn't have the EMS report from Hamilton as we went to put this out Friday. We still don't have it. I'll call them. I bugged them once last week and it was promised, so we may have to have a meeting on that. There was one day, I think it was early last week, where they had 4 calls going on between San Saba and Hamilton County. San Saba and Mills County, and 3 ambulances. So there was a delay, another ambulance dispatched from Hamilton to cover it, but it wasn't a car wreck with multiple casualties. It was just coincidentally 4 medical calls going on at once, which is unusual, but it did happen. There's the Veteran Service Officer report is in here, a total of 16 veterans helped, and you tend to think of the VSO filing primarily helping veterans deal with claims for the VA, but you actually see one case in here where he's trying to help the nursing home find a veteran so they can communicate about the veteran's parents. So it's really a full service operation. That is all of the monthly reports. Is there on the consent agenda? Is there a motion for approval or question?
Motion, we approve the consent agenda.
There a motion? I'll second it. Any discussion? So we have a motion and a second to approve the consent agenda, absent the EMS report, which is not included. So all in favor say aye. Aye. Any opposed? Okay, we're approved on the consent agenda. Number 5 is act on canvassing votes. I had this I put it on the agenda when we published, so it would be here. We are not prepared to do that, but if you don't mind, Ms. Scott, would you tell us when we do need to do this?
The 16th, the rules say that it couldn't start before today. And so Dudley and I haven't actually got to meet today because Commissioner's Court was this morning, and it has to be completed by the 17th.
So since our next meeting is the 23rd, can we approve it on the 23rd, or we have to?
No, it has to be approved before the 17th, but we couldn't start before today.
Got it. When do you anticipate being done, or is it too early to tell?
I was going to propose to the court that we meet on Monday, the 16th at 9 o'clock. The rules say only 2 commissioners have to be present, so it doesn't take all 5.
So it's not even a court action then, because 2's not a
I
quorum.
think it has to be.
It has to be. I think it may be the
Judge and 2 commissioners.
judge
Okay.
and 2 commissioners.
Okay, so we'll post it. So I'll do that for the 16th, and that'll be the only thing on the agenda unless something else comes up. So we'll pass on that item 5. Item 6 is Techshare annual indigent defense software contract of $317. This is not the state indigent defense grant that pays this money. This is a software company that serves most of Texas, most of the big cities. We piggyback based on our percent of cases and pay basically nothing, $317 a year for it. each year they ask that we execute an acknowledgement, or it's an addendum to the services agreement to recognize our obligation. The 317 is in the budget. It's less than we paid last year. I think last year might have been 322.
353.
353.
Yeah.
Okay. So that's what this is. And I would recommend, I would move approval of execution of the addendum to the annual Techshare annual indigent defense software contract.
So moved.
Motion and a second. Any discussion? All in favor, say aye. Aye. Opposed? Okay. Consider an act on updating some signature cards to add Sonia Scott, County Clerk. Ms. Busby, would you like to explain what we're doing?
We just need to change the signature cards at the bank to reflect Sonia and Julia and me and Joy.
Are there any questions on what we're doing? Is there a motion?
Make a motion to allow new bank signatures, the ones that Selena just mentioned to people.
I second.
We have a motion and a second. Any discussion? All in favor, say aye. Aye. Opposed? That's done. The next item on the agenda was the Rural Rail District, but I don't see anybody present from the Rail District, but I do see our attorney, Jeff Allen. So at that, I think let's skip ahead so we don't waste his time to discuss the potential tax abatement that will be looking at on the 23rd. And with that, Jackie, could you share the screen and load the slides, please? We have on the, there we go. Okay, let's flip to the next page. We'll start here. This is just a high-level overview of 312 of the tax code. The purpose of all this is to attract capital investment, create new jobs, and improve the local economy. So that's with that background. Let's change pages. This is what we have outstanding right now in Mills County that are, this does not include the pecans abatement, which is in its second and final year. These are the large abatements. The first one the county did was in 2014. It's on the left, Gulfway Wind Energy. The second one is on the right. We did it in 2018. It's called Flat Top. And see the relative investments, 205 million on one, 134 million on the other. And then there's some financial information on what's been paid just on county taxes. So this is county and road and bridge. It ignores school districts, and the school districts in general are about, I'd say 1.5 times the county tax, if you want to do the math in your head. But since inception on the Gulfway Wind Energy, which is also called Invenergy, the counties collected 3.9 million. On Flat Top, it's 1.9 million, but it started years later, so it's still running. And the 2020 tax is not paid yet. You can see 408,000 on one and 472,000 on the other. So basically, in our current county fiscal year, there's $800,000 of tax revenue that comes from these two projects that if we didn't have, either we'd have to spend $800,000 less in the county budget, or the taxes rate would have to be high enough to offset that and raise another $800,000 from our citizens. So that's where we are now. Both of those agreements, notice at the top are, I've just shorthanded it, 60%, 40%. We did them where 60% of the tax was abated for the first 5 years and 40% for the second 5. Let's change slides. Okay, we're looking at 2 applications now that will be coming. We've had the hearing to establish the reinvestment zone. We will have consider an act on these 2 in a public meeting. It has to be a regularly scheduled commissioners court, and that's November 23rd, so 2 weeks from now. That's why I wanted us to have some time to talk about it before we got down to that point. The Pretty Wind project is one name. That's the one that it's an old Invenergy project, generally runs northeast from town out to almost the county line. It's generally south of 16 and north of 84 East. The other one is Bluebonnet Wind Power. This is one that had been talked about for a long time. It's in the Payne Gap, Moline area of the county on the far eastern edge, and all of it is south of Highway 84. So that's where they are. On the Pretty Wind project, the investment amount is $311 million. Bluebonnet's a smaller project. It's $124 million. Both of them, the construction date is proposed to start in calendar year 2021 and be operational in calendar year 2022. You have to do the calendar work to see when that hits the tax year and the budget year of the county. The megawatt capacities are proportionate almost to the investment. 300 megawatts in the Pretty project and 103 in the Bluebonnet project. Turbine counts, again, proportional, about the same size, 4+ megawatts per turbine. So those are more powerful turbines than the early projects we've done. 63 in one project and 23 in the other. The employments are different. Now, this is a little different than we heard in the public hearing on the reinvestment zone. This is from the application. The applications say Pretty Wind would have 5 permanent full-time employees and Bluebonnet would have 2. Now, when they talked, they also talked about initial maintenance staff being provided by the manufacturer that would be around for a couple of years. That was an additional person or 2. And the implication was when the manufacturer warranty quits, they may have to hire people like that to maintain the turbines, but that's not what's in the application. And then the requested abatement. The Pretty Wind has asked for basically the same thing we've done twice before, 60-40 over 10 years. Bluebonnet has asked for 70% flat for 10 years. So that's a higher level of abatement on a smaller project. Let's flip the slide. Setbacks get a lot of discussion. That's probably one of our citizens' biggest comments. And so here's what we got in the applications. Pretty Wind is proposed 670 feet from non-participating property lines. They're proposed 250 feet from participating property lines. 745 feet from the center line of a county road, and 1,500 feet rounded from the center of any occupied residence. Bluebonnet has done taken a simpler approach and just said 250 feet from non-participating property lines, and that there will be no turbine sites within 1,000 feet of any structure, whether it's occupied, unoccupied, house, barn, anything that people might be around. So different approaches from different companies. Let's flip the slide. want to talk about economics. If you look at what's requested on the pretty side and the requested abatement, it's $7.3 million of estimated tax income to the county over 10 years. Now, there's some problems with this number I want to point out. The assumption the applicant makes is that the properties will lose value or depreciate at the average rate of 8% a year. Now, the problem I see is I went back and looked at the Invenergy project. That's the one we have that's been around for almost 8 years, and looked at what the average depreciation was there. And it's quite a bit higher. It's 11.6%. And it is, all this assumes the existing tax rate. So I think what we learned on Invenergy is it depreciated a little faster than the proposals that came to court with the original application. And I would anticipate that's going to happen again. So there's another alternative on the table, and that's called a pilot, which stands for payment in lieu of taxes. The way it works is the county effectively abates, or formally abates, 100% of the taxes for 10 years. And in return for doing that, it gets a contractual annual fee. It's not considered taxes. It's not collected through the appraisal district. It's just a negotiated annual payment. In this case, it could be hypothetically or not. Let's say the 10-year annual payment is $7.4 billion. So approximately so that's $740,000 a year divided by 10. So that's about what they're saying the taxes would be at the current rate, net of the 60/40 abatement, and assuming that 8% depreciation schedule. The fact there's the value difference of that versus running it, say, actual depreciation. If we took that risk, it got hit with 11.6% depreciation, as has happened on the Invenergy project, we would actually collect $1.2 million less. So going with a pilot on their proposed depreciation schedule gives the county, in my estimate, $1.2 million more money over 10 years, or $120,000 a year per year over 10 years, more than taking the risk on the depreciation. The Bluebonnet numbers, smaller. They asked for 70%. I didn't even bother to figure this based on 70% abatement. If you do it on a 60/40, the taxes would be about 1.7 million over 10 years. So say average 170 a year. If you have the same issue with the depreciation, so you could set up a pilot on that program and you'd still come out, run the numbers, you'd come out better off by probably $600,000. So that's one decision the court will need to make when we get down to approving. First of all, there's the binary decision. Do you approve an abatement or do you not approve an abatement? And assuming you approve an abatement, then there's all sorts of terms that have to fall out. Everything from taking the application at face value, the setbacks at face value, to imposing something else. And then it's to giving the abatement that's requested, giving some other abatement, or going with a pilot program. And I'm making the argument for a pilot program. I think I'll run through the rest of this and then turn it over to Jeff Allen, our attorney, get him live on the screen, and then let y'all be able to ask questions. I hope I'm stirring up at least some thought on the decisions we're facing. Can you change the slide? Okay, well, I've covered this. This is how a tax abatement works. Some of the things that are interesting about a tax abatement is a pilot, is it's not taxes. Therefore, it doesn't fall into the truth in taxation calculation that the legislature imposed. And at the end, the property's not on the tax rolls until the end of the pilot program. And that is important because then when it comes on, it's new property then. Otherwise, the issue keeps coming back to if you raise taxes more than 3.5%, there's a mandatory election requirement. And it's not that I'd say we're concerned about having an election. We'd have to explain to the county why we needed to raise taxes, but that's always an uphill explanation. And an election just in and of itself is going to cost us another $20,000 or more. So if you can avoid those issues, it's worth doing. Let's change the slide. Here are just some other things non-financial. We've talked about the setbacks. There's an active lobby, a small but active lobby that wants larger setbacks from property lines to protect property that doesn't have residences under the theory that it might someday. There's the issue that there's on the Pretty project, the substation is in the northern third of the project. The connection point for the power is past the southern end of the project, south of 84 and south of 572. And the company proposes to string an overhead line that entire distance. That's something we haven't faced as far as I know in our other projects. There's a little bit of community concern over that. There's the issue of is the reason this is happening because the substation's on the other end of the project, because at one point the power might have been going north instead of south. And so could the substation be moved, or should we not abate the overhead power line and let them do what they, we can't control building or not building overhead power line. We can deal with road crossings, but other than that, we have no land use authority. Our authority is the abatement. So that's something to keep in mind. There's the issue of, on the pilot program, there's different ways you can structure it. You can do a fixed payment every year. The company proposes, the companies, plural, want to do it, tied to megawatts of installed turbines. So the problem with that is you don't know until it's done what you're going to get. There's a hybrid approach that Jeff Allen has brought to my attention, where you'd say, okay, it's this much flat because this is what we're approving. And for every turbine you install past this, then it's so many dollars per turbine. So it starts where you think it's going to start and only goes up if they do more. That's
I think from that aspect, that's what happened at Flat Top. Then they add like 3 or 4 more that ended up in Goldway ISD school district.
Yep.
Isn't that right, Robert? Yeah.
Yeah.
So, yeah, they could add some after the project's already been approved.
Another thing we need to address is removal and remediation at the end of the project. I mean, this is 25 to 50 years in the future. So at one level, it's not our problem, but it is a potential problem. It's primarily a problem to the landowners, but we all know how that works. And at the end of the day, everybody looks to the county. So one thing we could do is have a requirement in the abatement that there be a removal bond. Now, it may not be the right amount 50 years from now, who knows, but at least there's something there. And if they don't, it's a default. Excuse me, defaults are really important. This isn't just like a regular contract where you're in, you can be in default and it may or may not matter. You may or may not hear. The ultimate problem with the default in one of these is all the back taxes are owed. So there's a huge consequence for non-compliance. puts a burden on the county to draft it carefully and to monitor it, but it also creates a powerful incentive for the company and its investors to perform in accordance with the abatement agreements. Do I have anything left, Jackie? Another slide? Maybe not. There we go. Okay, here's what happens next. And not next in the next 30 minutes, but over the next couple of weeks. Our attorney will draft the abatement agreement. So obviously we need to feed him some decisions. We have a formal decision to be made on November 23rd. Even following the formal decision, the county cannot execute the contract for at least 7 days following that approval we have to give required notice to all the school boards. Again, then there's the agreement. And then finally, and we may talk about this separately, we still have that road use agreement out there. We approved it in court September 8th. Commissioner Guerin has talked to representatives from NG. They're the only ones that are raising the road use agreement at this point. 60 days went by and they came back just late last week with a bunch of proposed changes. At this point, I just said, look, I'm busy with the abatement decision. This is just going to have to wait unless you can work something simple out. So it's up in the air. Some of it could be addressed in the abatement agreement. If the court wanted, we could pull it back to the front burner. Some of it's non-substantive. One of them is just correcting the list of roads. Our list came off a map and now they're saying it's really way more roads than that. But some of the substantive agreements concern, well, do they really have to put 4 inches of base out at the end of the day? And why 24-inch tin horns? Why not whatever an engineer says? I mean, that type of stuff. And then some of it is legal maneuvering. You know, this word should be reasonably practical or not to be unreasonably declined or things like that. Let's change the page. So that's what's on the table. Let me close the presentation, Jackie, and let's get Jeff Allen up here. And Jeff, I probably took a lot of liberties with the law in this overview. So why don't we start with you correcting anything I did wrong?
No, really, it's a pretty good summary of what is available to y'all. The agreement is open to negotiation for the commissioners of what you're comfortable with ultimately. There's a lot of leeway in there on the pilot, and that is what we've done probably for the last 5 years. Each tax abatement we've done has been under a pilot. That gives y'all some flexibility in structuring it however you want to structure it, whether it's through payments by megawatt or fixed payments or a hybrid of both. The benefit of that we found through other counties is just the certainty in budgeting. As Judge identified, these projects are aggressively depreciated. We've seen that in various places. So the hybrid or the pilot model does allow y'all to lock in a payment that you know you're going to get for 10 years and you're not in those situations. The same as with the rollback on taxes. That's another reason why we don't like having those coming onto the tax rolls is that depreciation. If it causes you to have to lower your tax rate, the benefit of those turbines is really in those first few years. When their value comes down in that aggressive depreciation, you know, that'll affect your budget. When we do it through a pilot, we avoid those issues and y'all can fix those payments. Typically what we do though, in order to kind of get an apples to apples kind of comparison is what we'll do is we'll look at what a 60/40 abatement would look like and see what your net present value over that 10-year period is. And then we'll set up the pilot such that it pays you similar to a 60/40 type abatement. I know one of the companies is asking for 70%. I don't remember the last time we did any abatement that was 70%. So that's probably not something that y'all want to do. But again, it's up to you. The times we have done something like that in the past, where we've had a high number, it's been for a short period, where if you want 70%, you might could get 70% for 3 years, and then it backs way off to be a 30 or 20% abatement the rest of the time. But those are considerations for y'all. Y'all are in a fairly unique position lately in that you have 2 projects on your table at exactly the same time. That presents some unique challenges in that you're going to be looking at 2 projects that are ultimately similarly situated, and they're going to probably want to look fairly similar. So we'll need to be a little creative in setting up the abatements to where you can accomplish what you want, but ultimately the discretion with you. You can grant abatement to one of them and not the other. I mean, y'all are the fact finders in this situation, and that's going to be something you really want to look at to see if it makes sense for you and your constituency in the county. As far as some of the other items, we do fairly often use those road use agreements inside the abatement. The deal with the abatement there is that it's a 10-year agreement. The positive of putting it in the tax abatement agreement is that you do have the recapture under a default to where you can hold that over the company. Problem is your tax abatement agreement expires at 10 years. So you would need to renew that road use agreement to last the life of the project if we wanted it to. I heard y'all talk several times about setbacks. There aren't legal requirements statewide for setbacks. So to the extent that that's a major concern in your county, we're going to need to address that in here. The setbacks that they're generally going to use, most of the time we see them not install turbines that are closer than a fall distance, which is exactly what it sounds like, meaning if a turbine happened to fall over, it's not going to fall onto another property. But really the only legal requirement there is they can't have their turbine blades overhanging the property line, because that would be a trespass. So to the extent that the people in the county are worried about setbacks, this would probably be the only opportunity y'all are going to have immediately to influence that. Judge talked about the overhead transmission lines and abating certain things. We can do that. The general, I guess, form that we most typically see would abate every improvement. It just says tax abatement is on the improvements, which includes overhead transmission line, substations, those sorts of things. We can be more deliberate as to saying we're only abating the taxes on turbines. Hypothetically, if they balk at any sort of setback, we could say, I don't immediately see a reason why we couldn't say we only abate turbines that are set back 1,500 feet from property lines. Y'all have a lot of discretion there in doing these agreements with the company. That puts a lot of arrows in your quiver to influence their decisions. Like I said, if they're balking on a setback, you can say, well, we won't put that in the abatement agreement, but if you turbine that's 500 feet from a property line, then we're not going to abate that turbine. That creates some issues with enforcement and those sorts of things, but it's something that we can have in our head. But we can do that. As far as remediation, there's state law and utilities code section or chapter 301 does have a requirement now for wind projects to have a removal bond at year 10. We still have put removal securities in abatement agreements, just in the sense of it would give y'all some of that leverage there. If you're requiring them to post that bond, which probably wouldn't reasonably be a reasonable ask until year 9 or the very end of the abatement agreement. What you could do is, as the judge mentioned, you could bring that under the umbrella of a default, where right now it's a lease default if they don't post that bond, which would jeopardize their lease. But if it's in the abatement agreement, it jeopardizes all those back taxes too. That's something y'all could do for the constituency. It's not something that we've done a lot on wind projects, but y'all are in a slightly different area than where a lot of wind projects have been done lately, just as far as the makeup of the county, the county's, I guess, view of them. It's a little more split. When you get out here west, there's very little opposition at all. Everyone's just comfortable with them. Nolan County, where we are, they're just ubiquitous. They're everywhere. So it's just a different situation. So y'all have some unique considerations that you have to take into there. But other than that, I mean, the big picture here is that y'all have a lot of discretion in what you want to do. And, we can draft it. You have that authority. We can draft it as you want it. And what you feel your constituency needs, we can put that in the abatement. We have the opportunity to make the original draft to shoot across. Probably what I'll do is I will give y'all, I'll send to the judge a couple forms of abatement so you can kind of look at them and just be familiar with them, and identify things you like and things that you don't like, and y'all can forward that back through judge. And so we can avoid any sort of open meeting sorts of situations, but we can kind of get each of you thinking about what the abatement looks like and what you don't like in it, like I said, and what you do. And then we can address those at various other meetings and do what we need to do. Normal process that we go through in negotiating these is we work directly with the county judge here and interface with the company. Typically a commissioner or two to avoid any sort of open meeting situations will help in that situation, just in kind of saying, this is what I feel like the group is comfortable with. Because what we don't want to do is, go down the left fork in the road when y'all want to go down the right fork. But that's a normal process. We try to keep everyone as involved as possible within the confines of the Open Meetings Act. That's our main, I guess, is making sure y'all are informed without violating Open Meetings Act requirements. So if I have any questions, I'd be happy to answer them.
So on the meeting on the 23rd, Judge, do we have to have, well, we're going to listen to their abatement. I mean, we've already got the application. Do we just listen, or do we sit and ask a lot of questions, or do we just, because I know it's a meeting and there's going to be public here too, is going to say, do we need to have our abatement ready and then they have their abatement and then we just cross out things, or how?
Well, this is interesting. And that's why I put this on the agenda today. From what I'm hearing from Mr. Allen is that in other counties, the approval meeting is perfunctory, if that's the right word, that everything's been worked out in advance. Now, that may be in counties where the whole farm's on one guy's ranch, or I couldn't see how that could happen. So I'm concerned either we will not be able, ultimately, this court should have an agreement in front of it to approve. Now, I don't want a lot of going back and forth. I don't know how productive it is to negotiate the agreement in a public hearing back and forth with two different parties that we ought to be negotiating with separately. And honestly, the November 23rd meeting, that was, the law said you had to put a notice 30 days in advance. So I was just rushing to get the notices made. I'm personally concerned on whether or not we're going to be in a position. I'm torn. I'd like to get this done and the economics known and the construction started. But as I sit here today, I'm not sure how we get it to an approvable point by the 23rd. I mean, Mr. Allen, you have suggestions?
Normally what we would do is we would negotiate it outside of that meeting and see how close to get to something that the commissioners we think would be comfortable with. So y'all would have what they're trying to say is their last and best offer. It always never, sometimes it's just not. Sometimes that meeting, like what y'all have scheduled on the 23rd, is just commissioners get it ahead of time in their packet and look at it and say, I'm good with this, and there's just an approval. That's not always the case. It may be one of those, that's the time where the commissioners are there to support the judge's communication to the company when we tell them, this isn't going to be approved. A lot of times they think that's bluster until you showed up that meeting and y'all say, we're not good with this. And that's what pops it off of high center. We usually don't necessarily, it can be somewhat negotiated in that meeting, but you don't want to be starting from scratch in that meeting. You know, if they've made proposal to where hypothetically they've said we'll pay $1,500 a megawatt and y'all have said no, we need $1,800 a megawatt. Occasionally in a meeting like that, everyone can say like, okay, we're good with 1765 a megawatt, but we would still have to go out and schedule another meeting to approve it later. It's a difficult balance primarily because of the constraints of the Open Meetings Act in that y'all can't all get together to approve it or to negotiate it without posting a meeting. And that's generally why we would go through either the county judge or the county attorney and try and get something to y'all. It may be that there needs to be special meetings to where there's a proposal to where everyone can get together, can go into a session and sit down and get everyone's direct feedback. We've done it that way before where we've kind of taken a couple steps in the exchanging drafts or exchanging proposals. And then there's a meeting, not necessarily to approve, well, not to approve it, but to sit down to where y'all can openly talk about it with each other's direct feedback. That may be necessary in this circumstance, especially when you're balancing two at the same time and two that may be presented to your community in a different way. Or, you know, as fact finders in this situation, y'all may be looking at one saying, this does look like it's going to be a positive economic development for Mills County. And this one, like, I don't know about it. It may not be, it may be just a wash and maybe we don't want to give an abatement on it. I think that's the way to do it. A short answer would be, we get a couple drafts from them with me and Judge sending it back and forth to them. And then there'd be a meeting set to where y'all are just reviewing it. You're not approving it. You're just looking at this agreement saying, I don't like this. I'm never going to approve that. Or I'm okay with this. This needs to change, those sorts of things. Because definitely.
Commissioner Jason Williams. So has a draft been created by them at this time?
I haven't seen one. I know what to expect because we've done them with Mr. Gregson before in the past. The draft that I'll send around to y'all or just the form is something that we've worked on with them in the past. So you'll see it and it'll look probably very similar. But the numbers and things won't be filled in, and particulars like setbacks won't be filled in. Particulars like removing overhead transmission lines from the abatement wouldn't be in there. Those would be things that we need to get for Mills County, as opposed to just this is a general tax abatement agreement in Texas.
A concern to this court, I feel like, is two issues. Is the setback, that's what we've heard from, and also the way we do the abatement, whether it's a 60, 40, or a pilot. And that's the concerns I feel like that we need to address and have in place before we go into this public.
So should we, I mean, we can do it right now.
Yeah,
Should we have a workshop and have a copy of this draft?
Well,
or
I think a workshop is called for, but I think it'd be more productive once we get a draft agreement and maybe some of the things in it. But let's just tackle one of them. The question to me, you know, it is a binary question: is do you go with an abatement or a pilot? Forget 60-40, but it could be any abatement versus pilot. So to me, it's a compelling thing. Tilt toward the abatement and numbers being equal. I'm sorry, toward the pilot. I said that backwards. And does anybody feel the other way?
What under the pilot program, what happens in a default? How does that work? I didn't hear anything.
Good question.
Mr. Allen is telling us, but we're guaranteed X amount of dollars for 10 years. If they default, I'll break up bankruptcy. What happens in that situation, Mr. Allen?
In the default, what we all would do is we would send them a notice of default that they hadn't paid. The consequence of that default is you have the county would then essentially levy a tax lien against them for the entire non-abated taxes.
So are you saying that a default in the pilot would default the abatement agreement, and therefore the property would be 100% taxable from day one and
Yes,
would be in delinquent for however many years it passed?
yes, we go back and recapture all of those taxes. That's the consequence of a default under the abatement agreement, is if they don't do that, then we go back and recapture all those taxes. That's why it's such a serious problem if they default for them.
What would the priorities be? I mean, this is not a tax, and it's not paid through the appraisal district, so the appraisal district wouldn't be collecting the tax or dealing with an argument over how much tax is due.
Can our county attorney speaking? He doesn't have a microphone. Are you able to hear him, Jeff?
Yes, and the appraisal district will still be assessing it. So those numbers will be kept. Under the agreement, they still continue to do that because they have to submit it to the comptroller and do those sorts of things. Those numbers will still be, it'll still be appraised. It's just their taxes will be abated 100%. So those appraised amounts would exist.
What about priorities with the bankruptcy filing? Would you still have the same priorities you do if it's a tax, or say there's a federal tax lien filed? Would you have any issue on this fee that's paid rather than the taxes that have already been assessed?
I'll need to check on that and get y'all an answer. I don't want to tell you one way or another right off the top of my head because I'm not 100% sure. So I'll find out.
Okay.
That's a good question.
Okay. So we have the tax lien priority question is a reason to consider not doing a pilot. Otherwise, are there any other issues with regard to pilot versus abatement?
I know I've talked with some other counties and they've gone the pilot route.
Yeah.
They feel like it's better for the county and I don't have a problem either way, but I want to make sure that we are protected as a county. The reason I asked that question.
Well, it's a good question, and it's complicated because we're dealing with two different companies here. One of them is a large public international company, and the other isn't. So,
And we'll have to decide that too. Will we
Yeah.
give both
No.
each company abatement or?
we can do them differently.
I don't know about 70% though for 10 years.
No.
I mean, I kind of like what Mr. Allen said, 70% for maybe 2 years or 3 years, but I'm not for 10 years. I mean.
Well, I mean, my concern on the smaller one is that we just need some certainty that it's going to get done because that project's been out there a long time.
Longer than the very first one.
Yeah.
And
So,
not only that, I'd like to see more people employed for full-time jobs in this county too. That's the whole purpose of the debate to start with.
well, it was one of 2 or 3 purposes, but yes.
Economics.
Okay, so we have the abatement versus pilot question and it hinging on basically a bankruptcy preference issue. We have setbacks.
Have you had signs that 2 individuals have been coming to court about the setbacks?
No, those are the only 2.
Okay. I haven't heard of
What?
Setback?
I've heard of 0.
Have you heard?
I haven't heard of anybody.
Has anybody heard
Just the
anything
two
about
that's been coming.
the
all the time.
overhead power line?
No, that's about it.
Okay.
Now, I wasn't on the court. I guess look at those 2 guys sitting over there. Did the CREZ line, I know it was eminent domain, but we didn't do any type of abatement or anything on it when it come through on the overhead line, did we?
No,
Yeah.
no, it's on the tax rolls.
It's
I know,
on-
but there was no
No,
abatement.
no, it was
Yeah,
not.
but no, we did not deal with.
So, I
that.
mean, so this high line, we could take it out of the abatement and and not be part of it? Is that what I'm understanding?
It's a negotiation. Everything's a negotiation.
So
We have
maybe
the
that-
absolute right.
That's part of their project though, was the highlight. It needs to stay in the, you could, I guess, take it out if you wanted to, but it's part of the project itself, is it not?
You'd think it would be.
Yes, but it's caused by the fact that the substation where everything goes underground isn't put down where the power lines are. That it
So
was
where's
a business
Blacktop?
decision.
Is there something, where's Blacktop substation?
Up on 218.
Wouldn't this be closer to go to it for a substation?
It got lines next door to it.
That's what I'm thinking, yeah. So they couldn't,
Depends on who they sell the service to. That's,
so I think this is gonna open their option to go either direction then maybe.
Yeah.
Right?
Right. I mean, I think it's just an economic.
flat top is underground. Is it not?
No, not all of it.
No,
From the substation to Comanche County, it's overhead.
So it's everything, the turbines are underground at the substation. And
As
then the
far as I know,
output,
yes.
output from the
Because they go
substation
across 16 and
is
it's
above ground.
right up on top of the hill.
I shouldn't ask. I want to make sure I know what's out here.
Yeah.
I don't know what's on this other part.
Question I have, Judge, if the company makes a deal with the landowners to run that line overhead and compensates them, do we need to have any say so in an overhead line?
No, our only say so is whether or not we get granted tax abatement.
No, but I mean,
Right. If they want to do it on their nickel, other than telling them they can't put poles and guy wires in the right of way, we can't. It's my understanding that's the extent of our authority.
okay, no, just-
What other issues do you guys see that need attention here?
I think we need to get the road agreement done, don't you, Mike? Is that
I
what
was
you're
going to
saying?
say that the road agreement, I know Jed's been dealing with it, but they're coming back, throwing it back on the.
I think we need to get that done.
Well, we need to bifurcate this stuff because there's just too much on my plate. If somebody in Jed, and it probably ought to be, I don't know, it's all going to be in Jed's and Robert's precincts.
Well, that's what I said all along. Those two are to be
Okay.
working on the road agreement.
we're visiting with Kirk Robinson Friday with Ensign. They're not going to be able to do that 4 inches of road base we requested.
Can they do 3?
It's the economic issue.
Yes. To me, it ought to be left up to Jed. If he has a problem in his road structure, that is, he comes back to that individual, that company and say, hey, you're gonna have to come back out here and fix this road up. I need 4 inches. That needs to be,
They agreed to that.
yes,
So we've got $100,000 bond, whatever on for that.
yes.
Robert and I talked about if they put 4 inches in when they left on those roads, it'd be great. Not count equipment, trucking and nothing else. $8 a yard on that material on their estimated 44 miles is $457,754. Over that. You're gonna have to spend over $500,000 at least before they get it put back. So they said they've never dreamed that they'd have to budget that much money.
Well, just to put it in perspective, I mean, we're talking about $7 million of unabated taxes, and which means there's probably another $7 million of abated taxes. So it's just another number. I mean, we could give a little more abatement. They could pay a little bit more, and we could hold fast on the 4 inches.
Now,
or we
Mike,
could-
didn't they do 3 inches on yours?
6, but not all of them. That
Not
was-
all the roads,
that's
just
the
the
whole-
only portion.
Yes, what I did is what they did is they came in and I wrote the routes out with them. And the roads that they had to improve before they could come down, they improved. Then after it was finished, the roads that I felt like there's a lot of damage to, they came back and fixed those.
Was that in an agreement in
It was a
advance?
handshake. Everything we did on that
But
project.
we have a road agreement with them beforehand.
I
I
don't
mean, we've got
remember.
that on file.
Okay.
If it did, I don't remember.
It's on file.
Is it?
Yeah, there's a road agreement on files, but, and it said, I'm already sure it said 3 inches though.
Is it gonna be for the 10 years?
Well, I mean, one thing we could do
I don't know
is
if it said 10.
Jed could look at that list of roads. I mean, I think that the expanded list is everything they touch. And maybe we look at it with an eye toward, okay, which ones are the real construction routes? And I don't know.
Well,
I'm fine with leaving it to Commissioner Garrett.
well, I do too. I think he needs to negotiate it and, or Robert, both of them work together, however you want to do this. But I know that they're gonna use a lot of roads in that precinct that's not listed because they didn't buy it. Because they keep a constant amount of traffic going all the time. And they try to separate that traffic. All your roads are gonna get a lot of use.
One good point that Jeff Allen mentioned is by writing some of this into the abatement agreement, it gives you some more teeth. If they bust the road agreement, we're left with the choice of it's a civil suit over a contract. If it's in the abatement agreement and it defaults to taxes, it's a whole nother kettle of fish. It's easier to manage. Now, you know, the point was the abatement agreement ends in 10 years, but our experience with the roads is all the road damage is on the front end, not all of it, but the heavy use.
I know it's a concern to the court and to these commissioners, but with Blattner, and I'm sure that'd probably be the construction people that put this up. I know, excuse me?
Blattner's already hired.
Yeah, to me, those people were great to work with. I had no problem with them whatsoever. And, but it was left to me to handle it. So that's the reason I keep putting it towards Jed and Robert.
Well, by the time these things start, it's going to be, you know, Jed and Dale Parton. So maybe we ought to have a 3-person commissioner and citizen committee that includes Mr. Parton, because he's going to have to live with it. He's going to have to operate, negotiate. I mean, he's going to be the one on the other side of the argument with Blattner about what was intended.
It would be a whole lot easier on this road agreement if one of them jokers would come down here and go those roads like you were talking about. And that way we kind of know where they're talking about.
Yes.
They've got roads on that agreement they sent that red line. I don't know what they got them in for.
There's roads over there. There's roads over there. Mine's not even in the project area that I know of.
Well, going out there to the Central Texas Goat Park, County Road
I know.
303, they got that in there. Now, what's it?
To get to the overhead power line, it's going to go that way.
Overhead power line comes before that, don't it? Or is it?
No, it's not that, but it'd be right there pretty close to it, but
Like I'm saying, you need someone in the project, once it's to drive it out with, but it's all, a lot of it just last minute that you have to work with. That's the reason I think it's so important for the commissioner to have authority over it.
Jeff, let me ask you a open meetings type question. We've published the 30-day notice for November, whatever it is, 23rd. If we get, as we work on this, let's say we're not ready on the 23rd, is it going to be 30 more days and another notice, or now that we've given that notice, can we start a meeting and keep pushing it out in front of us?
What we could probably do is, if we had to, we could recess that meeting without having to post a new one. I'll double check, but that may be what it is. So you don't have to post another one to where that meeting doesn't technically end, but you recess it for 48 hours or 72 hours or however long that you want to recess it.
Yeah, I don't know if 42 or 78 might make a difference, but.
Well, yeah, I mean, we've recessed them for pretty long. I don't believe we've ever had to repost and wait 30 more days.
Okay.
There's ways we can figure that out.
I like having that short deadline out there. The companies are chomping at the bit. It's a good negotiating angle. They have a hard date to force them against. That if they want to do this and get started, they need to come to an agreement with us, or we have delays. But at the same time, the county wants to get the revenue stream started. And these things hit our tax roll or not on January of each year. So if we miss January of 22, then it pushes the revenue stream off a whole year.
It's a whole year behind anyway. It's
Right.
completion of 2022, but we won't start taxing until what, 2023?
Correct. But we don't want to push that to 2024.
I agree.
Yeah.
I agree.
Well,
But
okay, if you would send me a draft agreement, I'll do some work on it and share it with the commissioners and back to you to be socializing it with the applicants, and let Commissioner Guerin and Commissioner Hall and Citizen Parton work on trying to get the road use agreement to a form you guys think the Commissioners Court would approve. We did approve one, but now it's changing. And we
It's
can
not
do that.
changing on our end though.
We can do that without a public hearing or meeting. Just need to get it back on an agenda.
and I don't want it to make 3 commissioners, but you two, I mean, Mike's been through this. He kind of knows, he's got a little more experience than anybody. So if you have some questions that come up, y'all, one of you ought to holler at Mike, and because he's a little bit more. Him and Robert, the only two that's been through this. So, and on Robert's, most of them stayed on one ranch in Mills County.
They
So,
don't pretty well one. We
yeah,
had 2
so,
roads that was really, we used a lot.
besides the state highway.
I was fortunate this project being the first one in this county, but I always felt like that simple as we kept it, the better off we were.
Yes.
And it worked that way. I'm not saying it's gonna work
Now,
this time,
and it'll be up to the commissioners, but I also don't necessarily want it to happen what happened to you, Mike. I want to protect where we stockpile the material at the end and then use it for a project that what it was not meant to be used.
Yes,
You
I-
understand what I'm saying?
I
So,
agree with that, because there's some places I knew my roads were gonna break down after they left. And so I made agreement with a couple of landowners to stockpile material on their property where I could go back and use
but we
it.
ended up using it for something else.
Y'all used it for the law enforcement. That is correct.
Not y'all, we.
Uh,
We're a court, so we're all listening together. So, but that's what I'm saying. I think we ought to protect those
We
precincts.
discussed this on Monday the 16th.
Yes, I agree with you, Jason, on it.
We
It's
can.
just tough.
I'll just
to
a good
deal with
idea.
it.
Put it on the
Yeah.
agenda.
I know, I felt like stepchild that was dumped in my lap and I had to deal with it.
Well, look, we're going to have a called meeting on the 16th to deal with the canvassing. So Commissioner Hall's suggestion, we'll just put this
on it
and
too.
the road use agreement on that agenda. We'll have the road use listed for consider and act in case it's ready. If it's not, we can just discuss it. We will have a further discussion on this because we can't act until the 23rd. And in that interim time period, I'll have a draft from Jeff. We'll have some markups, maybe feedback from the 2 companies. Any other suggestions, Mr. Allen?
No, I think that's good. That would be a good opportunity for y'all to get it and kind of get some real feedback.
Are you available on the 16th in the morning?
Yes.
Okay.
One question. So it was mentioned a while ago about monitoring the project. Who monitors that 10-year project or the 20 years? Who typically monitors?
Well, I can tell you for the ones we have now, they are required to submit an annual compliance affidavit and to the county judge who is responsible for receiving it. I get that letter and all it says is we certify we're in compliance. So that's not helpful. It doesn't say we have 16 turbines producing this many megawatts and we have 5 full-time employees and, any details. So my goal would be to make this a lot more specific. And I think it should come, it's got to come to an office, have it come to the county judge, have it be reportable to Commissioners Court annually. And then there's an annual report on the tax abatement, the compliance of
Because
all
I
the
just have
tax
never
abatements.
seen
in the
one.
county.
I've never seen one.
Yeah.
I just-
That's because it's not done that way. I mean,
I agree.
And I'll be glad to bring those compliance letters to you, but
But if that's all it says, I don't.
yeah, it's a letter that says we certify we're in compliance because that's what the tax abatement agreement required. I mean, I've asked them about it. They said we're not required to do that.
But can we cover all bases? That's the problem.
You can't, but you can cover all you can think of among us. And that's the benefit of having Mr. Allen, who's done 25 or 50 or 100 other ones. He's probably seen some go off the rails or things that people wish they had covered.
Sure.
And we'll still miss some.
Sure. That was good, the 16th.
Okay. Well, let's move on. I appreciate y'all's patience with this, but it was important to talk about. Thank you, Jeff. If you would send that shell agreement to me, I'll start on it.
I will. I'll get it over to you today.
Okay.
All right. Y'all have a good rest of the day.
Thank you. Okay. Yeah. Help. Where are we? Signature card 8. I was expecting, I was told we would have someone available by Zoom from the Rural Rail District. I don't see anybody signed in. The guy I was talking to was named Donnie Smith, who was with, as I recall, a feed business in San Saba. Jackie, if you're not muted, do you have any indication that there's another person in a waiting room or trying to get on?
No, sir. No one else.
Okay. Well, you've got the little package. Let me give you a little bit of background and we'll just not do anything with this right now. This guy, Donnie Smith, came to see me unannounced a week or so ago, brought in this little package. And apparently that rail line from Lomita to Brady was being abandoned. The paperwork had been started a year or two ago with the state because it was hauling frac sand to the oil fields and that died. And so they were just going to kill it. And with the involvement of Senator Buckingham's office, she created this legislation for rural rail districts so that a government entity could be formed, non-taxable, maybe like a soil and water conservation district, to manage a small rural rail line and charge rents for the use of it, contract to maintain the right of way. And anyway, so a group of shippers that want to use the rail line, and it was a couple of feed businesses and I think a rock quarry or a stone company that wanted to ship construction material. They are the muscle, I guess, if you would, trying to get this thing done. And apparently it mostly involves Brady, San Saba, and Lampasas counties. They have to come to us because we got 600 feet or something of it, plus the bridge or half the bridge, which is a big deal. I don't know if they could do it without us. I don't know that this does a thing for us. If the railroad, if the right of way is not abandoned, we'll get taxes on it, but taxes on 600 feet of right of way are not worth the time we're going to spend talking about it. But if we go in with the formation of a rural rail district, we'll have to put somebody on that board and deal with it. The best news is the bridge would be maintained and maybe protected. When I have to worry about, we'll have less worry about it being a county asset, kids falling off it, floods washing it out. And they had asked to speak to Commissioner's Court. So here's the material. That's why it's on the agenda. They had a Zoom invite. We'd arranged for them to be present to discuss and explain. I don't know anything past what I just told you. So now
you can be supporters of the project and go from there.
I mean, what
without many times.
Should I encourage? I mean, I just said thank you very much. I'll tell the court.
Yeah, we support you.
It's just
Good
one
luck.
one more. What do you call it? Governmental organization. Mr. Hale, do you have any? I know it's news to you.
I guess the obvious question I would have is why do we want to do this? And I would hope that somebody could give us a good reason why we want to do it. I don't.
Just creating jobs for the rural areas.
No, I mean,
That's the only
I've
thing I'm
always
saying.
heard of the rule of unintended consequences when you do something like harmless, when you open up a whole can of worms that you never even think of. So I guess I would be a little.
Well, I want to know if the project will happen if we don't go.
Yeah, I think
What you're saying.
that's the question is if we're a linchpin and we kill it, we've hurt our neighbors, but that's the only reason I can see.
There's one other aspect of that, Judge. A lot of those retired rural lines have been made into auction sites all over the state. I don't know if we did one of
Yeah,
those.
only 600 feet.
Well, it's
already 600 feet.
But, I mean, this little railroad has been around for a long time, and it's always struggled, it never had really done much. It got to going good when they were selling oil field sand out in Brady, and were hauling it back and forth to the rail line. Lomita, that's really when the thing was popping a few years ago, but when the oil business kind of dried up, the railroad went on too, so, I mean, this little railroad track is always struggling. I would be reluctant to get into something that I know has historically struggled with. I don't know. Like I said, I want to see what the pros and cons are and maybe go from there.
Okay. Well,
In Jacoby feed though, isn't that at Melvin?
That track goes all the way to
Does
Melvin.
it, does it? Okay, I
Yes.
didn't know it went all
There's
the
a
way down.
railroad track to Melvin. Now, I don't know if it's ever been used within the last 20 years.
well, I was told this track has a 5-mile-an-hour speed limit on it right now because the
I've never seen
condition
one
of the
moving
track.
over that fast.
Yeah.
Seen several rail cars rolled over.
Yeah, a few years
Same.
ago, just past the
Yeah.
cell farms out there, there was some that fell off the bridge there.
Well, that's what,
Judge, I'm moving we table it until we have somebody to have operation.
okay,
What they're wanting to do.
I'll second that. Do we have a motion and second? Any other discussion? All in favor, say aye.
Aye.
Tabled. Okay, where are we now? MCAD Board of Directors. We got, I think we maybe just mentioned this last time, the Appraisal District sent us a notice that we were, 2 of our directors' terms expire in December, end of December. And so they wanted reappointments so they could be sworn in for January. We're not, so we have some time on it. What keeps coming up on their agenda is the reorganization of the board of the appraisal district. And I thought, rather than just let the appraisal district reorganize itself, its board itself, that the county as one of the entities and appointing entities ought to give some guidance to our directors, say, here's some things, some ideas we would like on the table as you discuss reorganization. And so I just outlined some, it just threw things on a piece of paper, but things like term limits would be one of them. Maybe term limits for the officers. Then address how people, how they're appointed or what they're supposed to represent. And then just some random thoughts on what I thought made a good director. And the one goal, the one thing the appraisal district does, that's the wrong way to say it. One of the responsibilities of the appraisal district is not appraising, it's of the board, it's managing the appraisal district. And so I just tried to list what I thought some goals might be helpful for the board to establish. Here's what we want to accomplish. And then behind all that is just numbers showing what entities tax they collect, and then what percent of the appraisal district they represent. And then depending on the board size, and that's one of the issues potentially in a reorganization, I think there's a minimum board size, I believe it's 7. This is all under the tax code. There's a maximum board size, I think, of 13. And so depending on what size board, how many people each entity would be entitled to. Obviously, when you do statistics, it comes out in decimal places, and you can't have 1/3 of a director or 8/10 of a director, although I guess if you did it on IQ, you could. But in all cases, what it shows is the city of Mullen doesn't even get a decimal place director. So anyway, I thought that was useful information for the court. And I'd just like y'all's input of, do you think it, I mean, I think we should give our appointees some guidance on how to deal with this reorganization request that keeps coming up.
Jason, you serve on the board now. Have y'all discussed it as a board of kind of y'all's needs and wants instead of the county discussing it?
No, and it was, I assumed it was gonna be on tomorrow's meeting, and it is not on their agenda, and it was a big debate on the last meeting. And, at the front of the meeting, it was, one thing, at the end of the meeting, it was totally different. So I have no idea. I did follow up with a question, and I haven't got it answered, for the agenda, and why it wasn't, addressed on what they're gonna do. They cannot organize the board until next, like July and August. That's by statute. So I'm pretty sure that's all that reorganization is gonna come May or whatever, right in the middle of the budget processes and all that other stuff. So
What's the purpose of all this?
well, the purpose is, what brought it all up is that, that letter that we got that says Mills County has their votes, but only 2 of them can be in Goldthwaite School District. 2 of the representatives from Mills County. Star was annexed into Goldthwaite Consolidated Goldthwaite made Goldthwaite Consolidated ISD, which made 3 members on the board from Goldthwaite ISD. And that was the problem, that there's I think Gerald read it, there's a resolution or something saying that only 2 can be on there.
So
when Gary Daniels died, the court appointed me to fill his term. While I'm in Goldthwaite School District, J.C. Mason's in Goldthwaite School District, and Jim Runyon's in Goldthwaite School District. And so it was brought up in the last meeting that myself was wrong because I can't be on there because I made the 3rd one. That it was Jason, but after doing some research, we appointed Gary Daniels in 2011, and his house is in Goldthwaite ISD School District. He's always been in Goldthwaite ISD School District. So that mess up goes all the way back to 2011, way before I ever got on the board. And if you'll look at the Goldthwaite School District, it zigzags around his house. I have no idea why. But I'm sure there's a reason on the Goldthwaite ISD School District, but it zigzags around North Brown Cemetery.
Point being, though, they're trying to correct it, though.
They are trying to correct it. They found the mistake, but the mistake is since 2011 that it's been messed up. So here's the thing. So when the judge asked me the same question you did, and I said, well, there's really we don't have any agenda of what our representatives are supposed to do on the board. What do we want them to do? And the same thing with all entities. Do you want them to report back to your entity, or you just want them to sit there? That's the thing. And so I guess that's why the judge kind of wrote his synopsis here.
I'd assume that y'all have your guidelines from your board.
The guidelines from the board is we're supposed to do policies and procedures. And we don't do anything with appraisals or anything like that. We run the office over there is what we are. And then we do vote on different.
That's kind of what I felt like all along, is that the appraisal board sets policy and procedure. You hire a manager to manage it. And
And well, you do the legal stuff. The board is over the legal stuff. So like this lawsuit that's coming up and all that, you're over that.
so that's on the question I had, Judge, that, us putting suggestions before, I guess they can look at it and thank you for suggestions.
No, I mean, we're not making this suggestion to the board. We were gonna make the suggestions to our representatives on the board.
Okay.
So they had, I
I
mean,
thought-
theoretically, no,
Okay, it's gonna go, this is gonna go to
No.
the board.
no.
This, yeah,
Yeah,
that's
this is,
what I got.
It's like, okay, we got people representing the county there. They owe us feedback and we owe them guidance. That's my view on it.
our point is, these are their guidelines, not the
Yeah,
board.
yeah.
Okay. That's-
Okay, yeah, because the board, yeah.
I have a question. I think that where the mess up happened is whenever Star got consolidated in Gulfway, that made Gracie Mason part of Gulfway School District. So the appraisal board didn't have, that was a school decision and county decision to consolidate those. And that changed the boundaries. And so it should have probably been addressed sooner, in my opinion, as a taxpayer, as far as who is, where everybody's located.
There's a county decision on consolidation of the school districts.
No, but everyone voted on it. The schools voted. We had meetings out at Star and.
Correct. The school
Correct.
district.
That was school
Yeah,
district.
the school district.
Right,
Yeah,
but the guidelines at the appraisal district didn't change when the boundaries for the school districts changed.
Yeah.
That's where it was messed up.
Well, I've talked to an individual in Mullen that, not on the Mullen School Board or nothing, that would like to be on the appraisal district board. And I told him, go down and sign up.
well, they're recruiting
But
for
he's
the
not,
appraisal review board.
Appraisal
no,
review.
he don't want on the appraisal review board.
Okay.
Well, then he'd have to be appointed.
He
by-
can't, he has to come to
There's no
us
signing
or
up.
Mullen or somebody.
he'd
But
have
To be
he's
appointed.
not necessarily doing it for the city of Mullen, he's doing it for the area. up
Okay,
there.
the school district, yeah. Perhaps. I mean,
No, they've got a school board member.
And then in the county, though, he
Yeah.
needs to come in
Yeah.
and sign up. So
yeah,
we
he
can-
needs
we
to
can
come
vote.
through us. I
Yes,
mean,
yes.
the two people, you asked me last time,
That's correct.
what, Jason Garlick,
Mhm.
who was on the appraisal review board, has an interest in it.
Yeah.
And
And
Mark
another guy.
Topper, who lived, I think that's Mullen School District.
It's Mullen School District.
Yeah,
Mhm.
But usually we have a list of people that were willing to serve, we appoint.
yeah, I mean, we're not,
Yeah.
it's not on the agenda to appoint anybody today, or we would
Yes.
do that. But that's,
That's
I-
the way we done handled in the
Yeah.
past. So I don't see why we should change that. We'll try to.
well,
And so what we need is a list of names to come before this commissioner's court
Sure.
of who wants to be on it, and this commission court needs to come up with an idea of who we're gonna put on there to represent the entire county.
mhm.
And at least till the reorganization, because when they do the reorganization, if you go to 13 members, you're gonna get more people that's gonna be
Well,
on
that's
there.
really nice, that question about these guidelines here. The board's trying to restructure whatever they're trying to do from appraisal. We are to see their changes, and then we can appoint from that point.
But yeah, but they don't do that. They just throw it in front of the board and vote out there. And so we never have any input.
We have to appoint two board members in December, and they're not gonna do this redistricting
Till January.
till
July.
June or July.
Yeah.
You see what I'm-
Okay.
See that there's the timeline's messed up
I
there.
said something, and Wesley Peters did say that he would do it if it need be, and he got land and.
I think there's several people who just put it out to the.
Need to
public.
put the
Willing
names
to
out.
serve. We need to put it out, ask it for that, but it needs to go through the judge's office over.
And we can change all three of us that are on
Yeah.
there now. I mean, you can take me, JC, and off and just pick three new ones and replace all three of them if you want.
I agree.
So,
But it needs to come through the court, through the judge's
Yeah.
office.
but we'll have to do
List
that.
of
We're gonna have to
names,
set
we did
that
it
on
from that point.
either December meeting, I guess, or first December meeting, or
Yeah.
put it on the 23rd.
Nah, let's get past all this abatement stuff and we come back to the school
Judge,
board.
there's somebody else.
Yes, I was waiting for us to wrap up the that was just a discussion. Let's consider it discussed. I think that was right. Yeah. Well, we have a representative from the Brady Shippers Group online to talk about the Rural Rail District. And let me see if I can read. Could you introduce yourself, please, sir?
Yeah, please excuse me for my tardiness. My name's John Sheridan, and I'm with PW Gillibrand. We operate the silica sand mine down in Brady, Texas. And we've been trying to hit all the court commissioners' meetings in all 4 counties this morning. And I was supposed to show up in person, and I had a family situation and I couldn't make it, so I apologize. And I'll try to be brief. We are trying, the Brady Shippers Group is an informal collection of 3 companies, and it's Smith Co. out of San Saba, Jacoby Feed and Seed out of McCullough County, and PW Gillibrand of Texas out of McCullough County. And we're pretty heavily dependent on the railroad, the CTXR. And when they discontinued operations last July, it negatively impacted our business. So we have a vested interest. And now the owner of that railroad, Omnitrax, has filed with the Surface Transportation Board to abandon and discontinue service on that rail line. And we found out through a rural district based in Dublin, the Centex Rail District, that we could develop a rural rail district that would allow feedback from the counties to impact what happens with this railroad. Because it's been our experience, once they tear up the tracks and abandon the railroad, it's gone forever. And that greatly negatively impacts some of the local economies there. And I'm not a slick spokesman. I apologize there. I'm sitting at home right now. So what a rural rail district is, it's a governmental political agency empowered by the Texas legislature in 2009, okay? The essential purpose of a rural rail district is to preserve and promote rail activity in rural areas of Texas. And in the state of Texas, there are 43 rural rail districts, but none of them represent McCullough, San Saba, Mills, or Lampasas counties. And what we're seeking, we're not looking for money. We're seeking some assistance from y'all to develop a rural rail district. And we've already contacted the local state rep to help us with this. And it requires a bill to be submitted to the Texas state legislature. And I have some documents that I was going to deliver in person. I can send them an email, but I have a copy of the Transportation Code Title V that covers this. And to tell you the truth, we were blessed because these gentlemen up in Dublin have had a rural rail district since 1990, and they have kind of served as mentors to us. We don't want to be in the railroad business. We just want to have access to what's going on there, because despite a lot of energy and questions, we have no clue regarding whether the rail service will be reinstituted on the CTXR. And this has been ongoing since June of last year.
So when do y'all meet? Y'all have meetings, y'all come together as a group and meet?
Well, what we did, and I'm just being really honest here, the shippers were greatly affected by this. Our company, for example, we bought a frac sand mine, but we're primarily in the water filtration business, and we ship sand for water filtration. So the shippers just got together out of a common interest, and we found out that we had very little power to find out what was going on with the CTXR and Omnitrax. We could work with the Surface Transportation Board, but they're all the way back, in Washington, and, we're just three small companies in Central Texas. So then we found out, and I think Donnie Smith found out, this Central Rail District got into the railroad business, and I have a contact there that you guys could call, in the 90s, because they felt they were had no voice with the Fort Worth and Western Railroad that was abandoning tracks up there. So it's not in our interest to buy or own the railroad. This bill gives us access to know what is going on in regards to, do they plan to fully discontinue it and abandon it? Gives us some access to their revenue streams, because they do have some revenue streams. It just gives us a little bit of knowing. Again, we don't want to be in the railroad business. I'm highly stretched just being in the sand business. I sure can't manage a railroad.
One question that came up here is, why do you need Mills County? We have just a few feet of the railroad track and really no access to it.
The reason we included you is because we were encouraged by Centex to invite all the counties along the contiguous path of the railroad to include this in this, because through us, that should give you some information into the rail line. And then probably more important, what are the plans to maintain that bridge that I think is in your county? So
Yes.
We're not looking for anything monetary from you. We just want to be inclusive in regards to all 4 counties. We don't want to leave anybody out.
We're very appreciative of that and understand the motivation. Are there any consequences on your formation of this district if we do not participate?
I don't believe so, Judge. I will get back to you on that, but I don't think there's any consequences there.
Okay.
And that's just being fully, I'm not a lawyer, obviously. I don't think there's any consequences.
Does the court have any other questions?
I have none.
I have none at this time.
Mr. Hale,
Inform kind of what's going on.
Mr. Hale, did you have anything you want to ask? Okay. Well, thank you so much for participating via Zoom. You filled in some blanks for us. The court has the package that Donnie Smith brought a week or so ago, so we've read it all, and would appreciate being kept informed.
Sure. Well, and again, thank you for indulging me, because I know I'm very late. I want to thank Jackie Brooks, who, once I finally mastered Zoom, I got her a message and she got something to you, Judge. And thank you so much for your time.
You're welcome, and thank you.
Have a great day.
You too.
Bye-bye.
Okay. Consider number 11 on the burn ban. The burn ban we enacted, I think it was in August, has a statutory, and it's written into the ban, lapse date of 90 days, which is November 14th, which is before our next commissioner's court. So we need to either do nothing and let it lapse, or take action to extend it. I don't know if any of y'all have talked to any of the fire chiefs, but in the absence of rain, my inclination would be to extend it. We can always temporarily or permanently lift it when we get some moisture.
We're awful dry, and there's very little grass out in the pastures too, because,
Well, that's only in the pastures that people are grazing. Yeah.
I'd like to see us extend it.
Is there a motion?
I make a motion to extend the burn ban.
90 days. Okay. We have a motion and a second to extend the burn ban for 90 days from its expiration, which is November. Well, let's just do 90 days from today. All in favor, say aye. Aye. Opposed? Done. Commissioners' reports and requests. Commissioner Wright.
On county roads, 505, 506, 510. We've been having our signs come up missing. I don't know, we've replaced them a couple times. I got with the sheriff's office and told them about the signs, and they're gonna start watching those out there. But I put them up one day and done the next, so I don't know what's going on. We're gonna try to figure that out. And busy with road work, that's all I have.
Commissioner Guerin.
We're still busy with road work. Actually, we're taking equipment into Cowboy Salem today for his auction on 21st, I think. On a side note, I'd like to thank Craig Wright for doing what his job as a BSO. You can tell by looking at his BSO report, he's doing a good job. On the other hand, I'd really like to thank the young lady for doing a fantastic job with the election this year, and her co-workers, Joey, Julie, Dudley, all the poll workers and the election judges. I think they did super. She did, because she's only doing the job for 30-something days, and she pulled it out, so congratulations.
Thank you.
That's it, Judge.
Thank you.
We've been working up at Pretty. We finally got County Road 707. Hopefully all the landowners are satisfied. I've visited with Gerald. We've got it under control. Then we've hauled base over on 267 and 265. My hands will not be here Thursday and Friday. Of course, Wednesday's holiday. They're taking their floating holidays. And that's it.
Commissioner Williams.
Been doing some blade work, on County Road 531 and 550. We're on 536 today, and we're gonna do, Swinging Bridge tomorrow, and, going to Gerald's hopefully on Wednesday or Thursday, so.
We certainly need.
Yes, I know, it's bad, but maintenance work done, we switched out some tires and stuff on the dump trucks to keep the better tires off those dump trucks. And took the other dump trucks that we put on surplus, and I took them off the Cowboy for the auction that's coming up. No current news on Regency Bridge. I haven't heard anything. I'll try to get a hold of San Saba Commissioner today, see if he's heard anything. Also wanted to let you know, I kind of did a rough, the judge said something last time, and that is just kind of an overview on this next stage of this TIF grant. So we put on there, a bunch of us put on there on ours when we turned it in, that we were going to do the bid process of, doing some, not bid process, we're going to go out and use not local help to help on the construction of this. I just want y'all to be aware, if you're going to not do county people, we have to set on this of how we're going to put those concrete. We got to do a bid, how you open that bid, how you accepted that bid, how you advertise that bid. Basically, you're going to follow FEMA guidelines is what TxDOT is saying. Now, you can set your own ways how you're going to open those bids. What's your priority? You can go with the cheapest one out there, or you can say, well, I went with this one because, that reason. But you have to state, and I have to put that in the report. And also, we have to do those and turn those in 2 weeks before the project starts.
How do you get them to bid what they don't want to bid on it, Jason, if we don't have any contractors?
I don't know. I've asked that question. We may have to put it in other papers or something besides just Mills County.
Could you just advertise it, and then if you only get one bid, you advertise publicly, you have one bid, and it is by definition the low bid?
A lot of times I don't even get any bid. I have to go out and, solicit these
You
contractors.
have to advertise it.
Well,
So we're gonna have to physically advertise it to state that you're gonna do that. I mean, you can go and I can send you all the guidelines, but basically we're following FEMA guidelines. We're gonna have reports due. So when you do a report, everybody, you're gonna have to, how many log hours at work? I mean, I never went through FEMA. Yeah, you went through FEMA. But you're gonna have to say, this guy's gonna have to, these 3 road hands did this, and, this contractor did this and worked these many hours. We're gonna have to turn all that in. If we don't have that paperwork, then you may not get reimbursed for your money that you did.
How much is a grant for?
76.
76,000. And we, one of them have, we
Each
all,
one of us had 20 plus, somewhere, some of that a little more, some of that a little less.
y'all poured some low water crossings. I don't know what you plan on doing with this project, but that was my project was,
Yeah,
That
us
one-
3 had the same project. His is different, his is material.
yeah, and I don't know if it even covered, close to covering.
But Roberts was county only, so Robert put down there only county only. Us 3, we put down through the contractors too, so you have to narrow it down what you're gonna do and what versus the contractor is gonna do. So that's just a rough overdraft. There, I mean, it's pages and pages. I just kind of put it all on one page so y'all can look at it. And that's it on that. If y'all have any more questions, when y'all get ready to do that, we're gonna have to look at, I mean, if we're gonna buy 10 horns, if you're gonna buy a horn to put in, you may have to get a bid or
Then so. Even dirt we haul out.
or at least have different prices where they're located, and then you get heads, S&S, Sweetwater Steel, McCoy's, I don't know who else has it. I know all of them have it, so.
Well, like I say, on the projects that we're talking about, we all 3 of us have to have bids on all of it.
Well, not if you're gonna do, only what you're gonna use a contractor for. So if you're gonna do all the prep work yourself, and you're just gonna hire the cement mason, then all you gotta have is just the cement. If the county's doing the other stuff, then you could, if you're gonna hire the contractor to put in the horns and everything, then you're gonna have to have a whole bid on the whole project.
And we've never done that. I think we do all the prep work.
If
we
you're
have
doing
in
the
time.
contract part, you've gotta have the bid process done. Okay? Judge.
That's, yeah, I was just shaking my head. I mean, it just proves there's no such thing as free money.
No. Oh, by the way, I want to thank Jason too for the load of cleats you gave me and use on 411 on
The half load.
No, it was a full
Still the
load.
half load.
It was a full load, yeah, but I don't know how much got left on the highway, so. I had a breakdown on one of my trucks, so,
That takes the rest of the place of engineer cost is pretty.
yeah. Well, that's what I'm saying. If you have to get engineers and all that other stuff, whew. Also, I want to let everybody know I'd like to extend my thank you to everybody for missing the last court. I'm sorry I did not make the last court meeting. I had a death in the family. I don't know if all of y'all know, but my nephew committed suicide, and it's been a very rough week, 2 weeks for my family. It's been a rough week for Texas A&M also. We're dealing with a lot of stuff, but the county has been so gracious to me and everything, and I just want to say my thank yous to everybody. And again, my apologies for missing the last court meeting, so.
Well, we went ahead and held it without you.
I noticed, and y'all had no problems without me, so I guess I'm not that important, so.
Family comes first, Jason.
Anyway, but I just want to say thank you to everybody, and it's gonna be a tough while, so, but anyway, thank you all for everybody. That's it, Judge.
Okay, judge's report. I'll make this quick. It's been a long morning. We got a report from the governor's office on population estimates. I thought I'd share the estimated Mills County population, January 1, 2020, 4,875, down from 4,899 6 months before. This is not the census. They do this from a number of other metrics. I know they've come to us for building permits, septic permits, vehicle registration and the like. So it's sort of telling, and it's not us. If you eyeball the whole thing, most rural counties in Texas are forecast to see small population declines.
I thought we didn't all go from the cities, people moving out.
Yeah, but they're primary residents, yeah. Other thing I just might mention, COVID, we had I think it was 15 or 16 new cases last week, which puts us up to 41 active cases and 3 deaths here in the county. So it is still very much out there in the community. And
Brownwood on the radio had a large, over 100 this weekend. So.
yeah, the big hit this last week, I think in one day there were 11 plus 4, about 14 in one of the nursing homes, residents and staff. So it's there.
It's not over.
No, it's supposed to be, but maybe if we get the votes canvassed, that'll fix it. Okay, well, that's all I had, and I echo Commissioner Guerin on well done for the clerk's office for pulling off the election. You just forgot the last 10 boxes of votes in the basement, I think. Okay,
We had 70% of our registered voters turn out to vote.
is that a record?
I don't know if it's a record or not. I'm getting Dudley to verify it or not, but I know that everyone is just kind of like, no, that's a huge turnout.
Usually that happens in the presidential election, they'll turn out more of it.
Yeah, I think the last one, 16, it was in the 60%. So, I mean, it's even up from usual. Okay, it's been a long morning. I'd entertain a motion to adjourn. We have 3 motions, 1 second. All in favor, say aye. Aye. We're adjourned. We're going to publish an agenda.
Yeah, see,